My name is Bob Hawley, and I'm with the State Bar of California. And I'm here to talk to you about trust accounting standards and the rules and regulations that govern trust accounting for lawyers, particularly for new lawyers. One of the most important things that you'll do as a new lawyer is open a trust account. If you are working for government as a government lawyer or working in-house as an in-house counsel, you might not have trust funds, and in which event you wouldn't have a trust account. But if you're engaged in private practice, particularly if you're a solo, learning how to handle trust funds correctly is critical. One of the, unfortunately, more common offenses that we see at the State Bar of California from a disciplinary standpoint is what we call misappropriation. That's not necessarily the theft of client money, it's where money goes missing. Maybe it was stolen, or maybe it was just mishandled. And you don't want to be in that circumstance. Generally speaking, do we find that lawyers are really dishonest thieves? Well, a few. But for the most part, with misappropriation, it's not dishonesty, it's not theft. It's negligence, it's inattention, and it's not paying attention the way that you should. First and foremost, your best resource on this is to look at the State Bar's website, www.calbar.ca.gov, and under the ethics page that's on the left-hand side of the screen, there's a list of ethics and professional responsibility resources. All of them are valuable, but there's an trust accounting handbook that's an inch thick and tells you everything that you need to know, from how to add and subtract, which is something that lawyers sometimes can benefit from in the area of money, to the administration of the trust account, right on through the banking regulations and everything else. Everything you could possibly need to know is there. So that's available for free. You can download it and burn up your printer because it is lengthy, but it's for free that way, or you can purchase it in a nice bound fashion from the State Bar of California as well. But do consider that as a resource. Another resource for information about trust accounts, and particularly what we call IOLTA accounts, interest on lawyer trust accounts, which I'll talk about, is with your bank. Banks love lawyers because lawyers tend to have a fair amount of money flowing through a trust account, and banks love money. So talking to a bank about how to set up a trust account and the various kinds of accounts that you do is another valuable resource. The other resource that you need to have is the bookkeeper or accountant. One of your very most important first hires should be, instead of a new associate or a receptionist or a paralegal, a bookkeeper. The bookkeeper is going to keep you straight and narrow on an area where you are probably weak, and that is in accounting for money, billing, tracking the financial side of the business. So you don't have to hire one full-time. You can hire one part-time, or you can contract with a bookkeeper or an accountant, but do keep that in mind as well. The first rule in terms of authorities that we're going to talk about is the generic rule on safekeeping client property. It's Rule 4-100. That's a rule of professional conduct, and it says that you have the duty to safe keep, and that's a key word. Safe keep property. Money is property, and as a result, you need to put other people's money that's not yours in a trust account, and that's how you safe keep it. But it also property comes in other forms as well. It can be things, everything from a document to a piece of property. It could be a motorcycle, it could be a Van Gogh painting, it could be anything that ends up in your hands where the client is expecting you to hold it for them. And the duty you have from a disciplinary standpoint is to safe keep it. So if perchance you do have a client's motorcycle, you might not want to just park it out in the parking lot and leave it there until the client comes to get it. Because if it disappears, then that's your responsibility. Same with the Van Gogh. You may not want to just hang it on the wall. You need to have some place in the firm that is a place of safekeeping. It has to be fireproof. It has to be strong enough to protect things reasonably, because not only do you have the civil duty with respect to your fiduciary duties, in terms of protecting property, but you have this disciplinary duty where you can get into trouble for losing property as much as you can for losing money if it goes awry. There's a few other statutes and authorities to take note of. One is section 6069 of the Business and Professions Code that authorizes the State Bar to audit your trust account without your knowledge. So there's a need to make sure that you do keep it accurate, because whether we do so or not, the truth is that when you have become a lawyer and you take your oath and say, I do, you are statutorily authorizing the State Bar to check in on your trust account without your knowledge. 6091.1 of the Business and Profession Code mandates that your bank report to the State Bar should your trust account go below zero. If it becomes, if there's any payments, non-payments for insufficient funds, then the bank has a duty to report the State Bar, to report that to the State Bar, and then the State Bar will follow up, with you on that. Also, Business and Professions Code Section 6149 requires that an insurer report payments that are made in the settlement of a claim, and that will result, in a notice going to the policyholder that a payment was made. So if the payment is made and the money goes missing, the insurer has a duty to tell the parties involved in the process that the money's out there. So it's just a cross-referencing checks and balances system that makes sure that as money's flowing around in a lawsuit that involves an attorney, that that the State Bar is aware of and keeps track of the things that are going on. In terms of FDIC insurance, that's something to think about. You put your money in a bank as a trust account. The trust account must be what's called an IOLTA account. IOLTA stands for Interest on Lawyer's Trust Account. Trust accounts must be maintained in IOLTA format, and the interest is earned and the interest is paid to the State Bar. So in addition to the State Bar then uses that interest, I should say, so that you don't think that we're taking it and just spending it on ourselves, but we maintain a grant program that funds legal aid through that interest. So the interest that is swept from your IOLTA account is then used through the State Bar's Trust Fund program to fund legal aid services for representation of indigent folks. But FDIC insurance, the insurance that is there if you have your money in the bank and the bank goes under. The federal government insures it. But the federal government will only insure client money up to $250,000. But the good news is that it's $250,000 per client. So you have one trust account. If you have dozens and dozens or hundreds or thousands of clients, you don't have dozens and dozens and hundreds and thousands of trust accounts. You have one trust account generally. You put everybody's money in it, and then you have a bookkeeping standard that someone administers to keep track of it. But the money is insured up to $250,000 per client. So if you have $1 million in your trust account, but you have hundreds and hundreds of clients in there, and each client only has under $250,000, they're all protected. But you want to keep in mind that it is not prudent to have your money in an institution that does not provide FDIC insurance. In terms of other things, can you take credit cards? I'll just run through a list of things that you may be interested in. Yes, you can take credit cards. You can get paid by credit card, but there are issues there. When you sign up as a merchant, which you are, with a credit card company, to accept credit cards, you will enter into an agreement, and you need to make sure you look at the small print in that agreement, because the credit card company may want to have the right to go into your account and pull the money back if there's a dispute with the credit card holder. And to allow a third party to invade your trust account is a violation. So you don't want to agree to that type of thing. There are services out there that understand lawyers and lawyer trust accounts, and you may want to deal with them. Some of them are endorsed by local bar associations, so you may want to check with your local bar to see if there's a credit card processor that's lawyer friendly. Scamming, let me just mention this because this will be the final comment. In today's world, people are getting emails from lots of people from far away saying, I need a lawyer, and I got lots of money, and let's just set up this deal, and you respond to it, and the next thing you know that they respond and say, gee, thanks, I told the other side that I have a lawyer, and that means that they just sent me a check, so here it is. And so you take the check and you put it in your trust account, and you take your third out of it as you agreed to with the client, and you disperse the other part of it, and then the next thing you know, the bank reports to you that the check bounced because there was never any money there to begin with. not a good situation to be in. So when you get those emails from folks saying, I need a lawyer, and it sounds fishy, it probably is. Get a fee agreement with them, go through all the processes, document everything, and if you have somebody that's still with you after that, you probably have a decent client. Otherwise, it's a scammer.